India Legal presents Courts Roundup.
Hello, I'm Hishay and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceeding. And before we begin, here's the headlines. In Hathras case, Supreme Court reserves order in plea seeking court-monitored SIT investigation. Plea also demanded witness protection. In TRP scam, Supreme Court declines to hear Republic TV plea against Mumbai Police, says go to High Court. In Tablighi Jamaat case, Supreme Court allows foreigners to submit representation seeking permission to go back home, asks Centre to decide within 7 days. And Calcutta High Court quashes FIR against Babul Supriyo for objectionable remark against Mahua Moitra during TV debate.
India Legal presents Courts Roundup.
The Supreme Court has heard the batch of petition in relation to the Hathras incident and reserved the order on court-monitored probe, and a bench of Chief Justice of India S.A. Bobde, Justices A.S. Bhopana and V. Ramasubramanian have heard the matter. Solicitor General Tushar Mehta briefed the court regarding details of security deployment outlined in the affidavit filed. Advocate Seema Kushwaha, lawyer engaged by the family, makes submission before the court, argued that the trial should be transferred to Delhi. To this, CJI Bobde said that I think last time all the counsel very fairly suggested that this matter must go to Allahabad High Court. Tushar Mehta said that the victim's family wants your lordship to supervise and we have no problem with that. This is not adversarial. CJI Bobde said that we will supervise in the sense we are the ultimate supervisors and appellate body. Mehta raised a concern on an officer of the court stating that the identity of the victim is revealed in the Allahabad High Court, and this, Mehta says, is not permissible under the Code of Criminal Procedure. CJI Bobde said that we can delete that suo motu. On October 6, the court asked the state of Uttar Pradesh to place on record the steps taken by it with respect, providing witness protection to the family of the victim. The court had also taken note of a submission that was made during the hearing, which claimed that lawyers were soliciting their services, which also led to court to seek reply on whether or not the family has chosen its legal representatives. And the Supreme Court has refused to admit Republic TV's petition to quash Mumbai Police summon and seeking a CBI probe into allegations of rigged viewership ratings, saying that the channel should instead approach the Bombay High Court like any other citizen facing investigation. Republic TV is among 3 channels that are being investigated by the Mumbai Police for allegedly manipulating ratings to get high advertising rates. The court said you have already filed petition in the High Court. Entertaining this petition without High Court sends a message that we don't have faith in the High Courts.
The Supreme Court has refused to entertain a writ petition filed by the company running Republic TV and its chief Arnab Goswami seeking to quash the summon issued by Mumbai Police in FIR alleging manipulation of television rating points. TRP. The court granted the petitioners liberty to approach the High Court. We must have faith in our High Courts. Without the intervention of the High Court, it sends a bad message to the High Court. They have been functioning throughout the pandemic. Justice D.Y. Chandrachud remarked. go under Article 226 or Section 482. Justice Indu Malhotra, to weigh at this, senior advocate Harish Salve, appearing for the petitioner, agreed to withdraw the plea to approach the High Court. During the short hearing, the bench also expressed concern at the practice of police commissioner giving press statements in relation to cases. We are also concerned by the way police commissioners are giving interviews to the press these days, Justice Chandrachud remarked. A bench comprising Justice D.Y. Chandrachud, Indu Malhotra and Indra Banerjee considered the petition jointly filed by ARG Outlier Media Private Limited and Arnab Goswami. In another related development, Mumbai Police filed an affidavit before the Supreme Court and has said the Republic TV is attempting to turn the FIR in the TRP scam case into a media spectacle and that right under Article 19(1)(a) of Constitution cannot be used as a shield against commission of a crime. Terming the writ petition as a gross abuse of process of law, the Mumbai Police has urged the court to dismiss the plea with exemplary costs. The affidavit states that the allegations contained in the FIR cannot be decided at this stage of the proceeding and that there is no exceptional circumstance which warrants the interference of the court under Article 32. Republic TV's Chief Financial Officer S. Sundaram had moved the Supreme Court challenging the summons issued to the network in relation to the TRP scam claimed to have been unearthed by the Mumbai Police. It was on 8th October that Mumbai Police told the press that it has detected the fraudulent practice of TRP manipulation. Republic TV and two Marathi channels were said to have been arraigned as accused in the FIR. A household comprising people who were not literate always had an English news channel switched on. They were paid about 400 to 500 every month, said the police. Bureau Report.
A petition has been filed in the Supreme Court by two lawyers seeking the removal of Andhra Pradesh Chief Minister Jagan Mohan Reddy for making allegations against the sitting judge of the apex court. Filed by advocate G.S. Mani and Pradeep Kumar Yadav, the PIL prays for the removal of Reddy from the constitutional post held by him for having made a scandalizing remark against the second senior most judge of the Supreme Court, Justice N.V. Ramana. The PIL alleges that Reddy himself faces a plethora of cases, including those related to the money laundering and corruption, by using his constitutional post to level false, vague, political and scandalized remarks and allegations openly in public and media against a sitting judge. Reddy is liable to be deemed unfit to continue in his post. The plea also states that also argued that while Reddy has the right to raise his grievances before legal fora in the country, he does not possess the right to misuse his constitutional post for scandalizing the judicial system in this manner by sending a communication to the Chief Justice of India. The PIL also says Reddy had sent a communication to the CJI S.A. Bobde earlier this month, leveling a number of allegations against Justice Ramana, who is next in line to become the CJI. The allegations pertain to corruption and even bench hunting, among others, and these allegations were also publicly announced by Reddy in a press conference held days after they sent the communication to the CJI. Earlier this week, a similar petition was filed in the Supreme Court seeking direction to Reddy to refrain from making public statements or holding press conferences to malign the august institution of the Supreme Court and its judges. The Supreme Court has allowed foreign citizens who are facing criminal proceeding in Delhi for participating in the Tablighi Jamaat congregation at Nizamuddin Markaz during March, allegedly in violation of visa condition, to submit representation before the nodal officer proposed by the central government seeking permission to go back to their country of origin. A bench headed by Justice A.M. Khanwilkar ordered that such representation should be decided preferably within a period of 4 days, but not later than a week from their receipt. Additional Solicitor General of India K.M. Nathraj proposed the name of Joy Tikhe, Deputy Commissioner of Police Delhi, as the nodal officer to process the representation of foreign nationals facing cases in Delhi. The Additional Solicitor General told the bench that 8 of such foreigners were discharged by the trial court, and revision petitions have been filed against the order of discharge. The court said that the discharged persons are at liberty to file applications seeking a return to the country of origin, subject to giving undertaking and security before the trial court. Further, it required that all the other foreign nationals may make representation to the aforesaid officer, who will have the responsibility of processing the same in 4 days and not later than 1 week in any case, subject to fulfillment of such necessary condition as may be applicable. The Supreme Court has issued notice in a PIL seeking the use of plain language in laws, government orders, notification, and etc. to make the law accessible to the general public. Notice was issued today by a bench of Chief Justice of India, S.A. Bobde, and Justice A.S. Bhopana and V. Ramasubramaniam. CJI S.A. Bobde told the lawyer, another argument you should make is that if the English is not spoken with simplicity, then people will move away from using it at all. In order to facilitate access to justice for layperson, the petitioner had also sought direction to the Union Law Ministry to make available guides and handbooks on laws of general public interest and redressal of grievances in easily understandable language. The petitioner lawyer, Dr. Subhash Vijayaran, has based the plea on the basis of the fact that the writing of most lawyers is wordy, unclear, pompous, and dull. The petition states that too much precious time, energy, and resources of both the court as well as lawyers is wasted due to badly written or verbose draft and ad nauseam oral arguments, and that there is a need to prioritize and effectively use resources if this court is to be truly a court of the masses and not court of the fortunate few. The era of never-ending oral arguments and verbose pleading has to go. The Delhi High Court has granted bail to a man named Mohammad Rehan, who was arrested for allegedly rioting during the Delhi riot after noting that there was no CCTV footage, video clips or photo to corroborate prosecution's claim. The bench of Justice Suresh Kumar Kate was hearing the plea filed by the petitioner under Section 439 CRPC for grant of bail. The SPP opposed the present petition by stating that during investigation statement of P.W. Kahil was recorded under Section 161 CRPC and had seen the incident and also identified the petitioner along with other co-accused persons. The said witness was able to identify the petitioner as he knew him previously. Moreover, statement of Irfan Salim, Surinder Singh and Pradeep Kumar Verma were also recorded under Section 161 CRPC, who had also seen the incident and had identified the petitioner along with other co-accused persons. They also knew the petitioner previously, and on the recording of their statement, the petitioner was formally arrested in Mandoli jail and as he was already in judicial custody. The court observed that it was not in dispute that in the present case there was no CCTV footage, video clip or photo to corroborate prosecution's claim. Further, the court noted that statement of Constable Pawan and Constable Vikram were recorded, being eyewitnesses whereby they identify the petitioner. Delhi High Court has imposed a cost of 5,000 rupees to recovered from the salary of the jail superintendent concerned and paid in the account of Bharat Ekavir within 1 week from the receipt of this order. The bench of Justice Suresh Kumar Kate imposed this cost on the jail superintendent as he failed to comply with the court's order, whereby he was directed to send a medical report clarifying if the petitioner is suffering from asthma and the treatment being given to him in jail is in this regard. The present petition was filed under Section 439 read with Section 482 CRPC on behalf of the applicant petitioner for grant of interim bail in FIR. He was referred to GTB Hospital for treatment. There, as per clinical examination and report of PTA, conservative management was suggested. Petitioner kept complaining that he needs surgery for his hearing loss as he is not getting relief with the current treatment. In this regard, he was referred to DDU Hospital. They said hospital thoroughly examined the case, reviewed the past treatment records and tests, and finally suggested conservative management. The same is being provided to him from jail OPD, and the case of the petitioner is that he is suffering from the asthma since long, and he is facing problem in jail with living with the help of breathing medical pumps, and thus he wants to get proper checkup of his body in a private hospital. In view of the above, the court granted interim bail to him for a period of 45 days. While dealing with a plea seeking financial aid for advocate clerks, the Karnataka High Court has asked the petitioner whether the state government could be made responsible for the reduced filing of cases. The bench stated all three benches of the High Court are working in full strength. Trial courts have reopened substantively, and should this exercise of financial aid for advocate clerks be done now? As far as the Dhawat bench is concerned, the bench is working at full strength, and Naik then informed the court that the COVID-19 situation had not changed much. To this, the court asked the situation that existed then when the petition was filed. Does that situation exist now? The court further expressed hope that filing of cases would increase since courts are functioning in full swings now. As the matter drew to the close and the bench asked whether the advocate clerks were being paid now, all the counsel said that it would ultimately depend on their employers. And with this regard to the related plea filed by Advocates Association Bangalore challenging a state government order refusing to consider representation made by Bar Association seeking financial help for lawyers amid the pandemic, the court directed the Karnataka State Bar Council to file objection by November 5th. Earlier this month, the Karnataka High Court had directed the Karnataka State Bar Council to set apart a reasonable amount for advocate clerks from the 5 crore rupees that the state government had dispersed to aid advocates amid the COVID-19 pandemic. And now we are joined by Advocate Divyanshi for more update on this.
Yes, in this case, a plea has been filed before the Honorable High Court of Karnataka seeking financial aid for advocate clerks. And in this plea, Advocate Murthy had pointed out that filing of cases has significantly reduced due to corona pandemic. On this, court has asked the petitioner whether the state government could be held liable for the reduced filing of cases. Court has further asked if the situation is really same now as it was then when the petition was filed. And the court has asked Karnataka State Bar Council also to file objections by November 5 and ordered to list this matter on November 6.
Well, thank you, Divyanshi, for the update. Moving on. Kerala High Court has warned against the general trend of divulging the materials collected during pendency of any investigation to the public media. It has said that stringent action will be taken by this court. The bench of Justice P.V. Krishnan observed that investigating officers in sensational cases are leaking confession statement of the accused, and the media is giving wide publicity to such statements, especially in sensational cases. Deprecating such a practice, the bench reaffirmed an investigating officer cannot divulge any materials collected during the investigation to the public or media. Justice Krishnan remarked that the practice of leaking information on part of the investigating agencies as well as the media impinges upon the fundamentals of criminal investigation. It therefore warned that if above direction are violated either by the police officers or the media, stringent action will be taken against them. If there is any violation of the direction of this court, the consequences will be serious. This court cannot sit as a silent spectator in criminal justice delivery system. If the confession, statement and other materials collected during investigation are discussed in media and divulged to the general public, the situation will be perilous. The bench added, and the remark were made while allowing the bail application of Jolly Joseph of Kodathai village of northern Kerala, accused of murder of 6 of her family members over a span of 17 years by administrating them cyanide. And the High Court of Kerala has directed the Enforcement Directorate not to arrest M. Shivashankar, IAS, former Principal Secretary to the Office of Kerala Chief Minister till October 23rd in the gold smuggling case. A single bench of Justice Ashok Menon passed the interim order after considering the submission of Senior Advocate P. Vijay Bhanu for the applicant and Additional Solicitor General S.V. Raju for the ED. Vijay Bhanu told the court that Shivashankar was willing to appear before the agency and undertook to cooperate with the investigation in the case registered under the Prevention of Money Laundering Act in relation to the alleged smuggling of gold through diplomatic channel. The senior counsel added that Shivashankar was questioned by the NIA and the custom for about 90 hours. And even after 100 days of investigation, the agencies have not found any incriminatory against him. Shivashankar conceded that he had acquainted with accused Swapna Suresh as she was working as secretary of the UAE consulate at the state capital during 2018 and 19, and that he used to have interaction with her in official capacity. He said that until the news report about the gold smuggling case appeared, he had no knowledge that Swapna was involved in smuggling gold misusing diplomatic channels. The Calcutta High Court has quashed a police charge sheet against Union Minister Babul Supriyo for passing objectionable comments at TMC MP Mahua Moitra. And during a TV debate in 2017, Moitra, who was elected as a Lok Sabha MP in 2019, had filed an FIR against Supriyo, alleging that he had made comments that amounted to intending to outrage her modesty during a debate on a national television channel in 2017. While quashing the charge sheet, the court ordered that from the above discussion, I have already come to conclusion that the allegations in the first information report and other materials accompanying the FIR do not disclose any cognizable offence under Section 509 of the IPC. Therefore, the charge sheet filed under Section 509 of the IPC is liable to be quashed. The court further held that the utterance made by the minister was a defamatory statement within the meaning of Section 499 of the Indian Penal Code and granted liberty to Moitra to take any action according to law if available to her against the petitioner before the appropriate forum and in such case during the ending moment of the program. At a comment that Moitra made, Supriyo had asked the MP Mahua, "Are you sure you are not on Mahua? Mahua is an intoxicating drink widely used and consumed in certain districts of West Bengal." That's it for Courts Roundup today. Thank you for tuning in. Keep watching APN for more updates from around the nation.
India Legal presents Courts Roundup.